Hello, and welcome to another episode of Million Dollar Breakdown, where we delve into our biggest verdicts from the attorneys that won them. And today we're speaking to Sumeet Kaul, a managing partner at Morgan & Morgan's Tampa office. Sumeet, you've in fact obtained several trial verdicts in excess of $1 million, but today you're here to talk about a very recent $3.2 million case. So let's jump right in and ask if you can give us a summary of the incident that led to this case.
Sure, Carl. Well, first of all, thank you so much for having me and inviting me onto your program. The summary of this case, it was a motor vehicle collision case where my client was rear-ended and suffered what we contended were permanent and significant forever injuries.
Am I correct in understanding that there was no pretrial offer here?
Well, there was a pretrial offer. There was an offer of $285,000. Then several days before trial, they made two moves to $385,000 and then to $485,000, which were not accepted.
And you've described your client as one of the sweetest, kindest young ladies that you've ever met. Tell us a little bit more about her and what her world was like before this accident.
My client was just a special lady. She was a hard worker as a child, was in honors programs in high school, went to undergrad at the University of Central Florida, and was actually in graduate school just prior to this crash happening. Everybody who knew her said that she was just high energy and loved life. She was very active. She was an athlete when she was younger. She also loved Disney. She and her boyfriend, who's now her husband, they would go to Disney because they lived in Orlando from the crack of dawn till it closed at night with the fireworks, and that was their passion. And that's really who she was, just an honest, sweet, incredible young lady.
Right. What factors for you did this case hinge on?
First and foremost, it was the truth. The case was all about the truth. And the case was about what had been taken away from my client in terms of her health. She had no prior injuries. This was a very significant rear-end crash where she was not at fault. And she had unrelenting, unforgiving pain ever since this crash and went under numerous medical treatments that were consistent. And she was also very, like I said, honest, sweet, incredible young lady.
When you look back on this case, what would you say were the biggest obstacles for you?
The biggest obstacle was she didn't have treatment right away. She waited about 7 days to get her first treatment and then waited about 16 days after the crash to get the next follow-up treatment. So the argument was, well, these injuries can't be related to the crash. So that would have been the biggest obstacle in the case.
You've also said that your colleague, Daryl Kropog, did one of the best jury selections that you've ever witnessed. Tell us about how he approached that jury selection.
Yeah, Daryl is an amazing attorney, and he has just this great rapport with the jury. And he was able to get out the jurors that would have been biased against our case and those jurors who would just be fair. We're just looking for fair jurors. And he was able to get them talking about, lack of hesitation of awarding millions of dollars in damages if the evidence warranted. It was one of the best jobs I've seen in my career of somebody picking a jury.
Amazing. How did you prepare for those arguments that opposing counsel might bring to the table?
Well, we thoroughly review the case and the chart. And what I would tell any lawyer who's trying a case, know your file inside, outside, backwards, and forwards, because you never know what the opposition is going to spring at you. So what I like to do in the preparation of my cases is I use TrialPad, which is kind of like a PowerPoint, but I'm in control of it. So I know where every document is. I know what everything is said on every document. And when they were alluding to documents where we felt weren't showing the complete picture of the case, we then showed the complete picture of the case so that the jury could see the truth of the entire record. So it's really, you prepare for what they're going to argue. We knew what their doctors were going to say. We had his report. So I prepared my cross-examination based on his report. And under our law, their doctor is not allowed to deviate from his report. So he can't offer new or surprising opinions to us at trial.
Given that, how did your team approach and prepare for those closing arguments?
What we do is, and what I've done throughout my career is, I prepared the opening. I think the opening is a very important part of the case that a lot of attorneys ignore, because it's the last thing you do on the case, because you have to know your entire case all the way through before giving an opening. And what I've done consistently, and what we did in this case, is we tell the jury, we build a theme of what we're going to prove to them in this case. And our theme was simple. The theme was, we're going to prove to you what's been taken away from our client in terms of her health. And we consistently backed up that theme with evidence in the case, not what could have been or what should have been, but with real evidence in the case. And again, you have to know your case forwards and backwards to build that, that impenetrable theme of the case. And reiterated that theme in closing. I told the jury, hey, in opening, I told you we would prove that this case is about XYZ, and I've proven that to you. And I just don't say I've proven it to you. I tell them how I've proven it to you. I've proven it to you by, here's the evidence in our case. There was no priors, and there's been unrelenting, unforgiving pain ever since. And then back it up with what activities she used to do that she's having a challenge doing now because of those injuries.
Right. And then finally, what did you learn from this case? What were the key takeaways for you and your team, if any?
What I learned from this case is what I've known really throughout my career. My grandfather, peace to his soul, he was a lawyer and a judge in India. And he came to my law school graduation at the University of Florida, and he told me, he said, as a young lawyer, always out-prepare your adversary. Okay, so I like to think I always do that, and I feel that we did that in this case. So you just have to out-prepare your adversary and know your case. And then, what that helps is, that helps you prepare for the unexpected. So when somebody throws you a curveball at trial, since you know your case so well, you're able to respond. And with TrialPad, we were able to respond very quickly for the unexpected by showing records that refuted what the opposition was telling us. And like I said, we sat on the right side of the truth, and the case to us was just very clear and obvious. And the jurors believed everything that we told them because we showed them the truth.
I love that advice. Sumeet, congrats to you and your team on what is a really significant win. And thanks again for sharing your insights about this case with us today. Thank you.
You're very welcome. And thank you so much for your time, Carl. I appreciate you.